It literally is like playing out like a movie in my head. Hey guys, this is Jules with True Crime Reactions. Disclaimer, everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, we're finally on the last one that we have to go over before we start digging into the motion to suppress the actual arrest affidavit. This one is a little interesting, just because we know at this point that they actually entered Bryan Kohberger's parents' house at 1:14 in the morning. But then we have this crazy timeline now developing within these motions to suppress that are showing a criminal complaint prior, but then another criminal complaint afterwards around like 4 o'clock in the morning. And now we need to go back in and try to repiece the timeline with all of these new little tidbits of information that we've received over the past week and a half or so. Now, to me, them entering at around 1:14 a.m. and then not swabbing him, photographing his body or anything until 4:10-ish, that gives a long time. That's like 3 hours. I think in the last video, I said it was like 3 hours and 45 minutes, but that's off by an hour. It's 1:14, 2:14, 3:15, and then almost to 4:15 before they actually swabbed him. Now, what I want to know is what in the shit was actually happening in that house with the entire family for almost 3 hours. What was happening? This was a scary situation. This was them breaking into the home in the middle of the night with their guns out, lights just flashing all over the place. They're lucky that Bryan Kohberger's parents did not have a freaking stroke, a heart attack, a panic attack, that somebody didn't fall out. I mean, seriously, it was just an insane situation. And then we find out through all of the rest of the information that we're getting through these that the feds were surveilling Bryan for quite a while, for a few weeks. In my opinion, at this point, until I sit down and actually get this timeline in front of me, it had to have been at least 3 weeks of actual surveillance. And in these, what have we learned? That he would go for a run every single freaking day by himself, unarmed. Yet they chose to break in to his parents' house in the middle of the night with their guns out, freaking everyone the hell out. I mean, I agree. That's absolutely wild. If they knew for a fact that he went on a run by himself every single day with no weapon, why didn't they just handle the situation that way? Now, this is the one that we are about to go over, the warrant for 119 Lambsden Drive. Can you believe that I had some idiot in my comments telling me to stop reading the address, even though it's the name of the literal document, and basically threatening to put my information out there because I was reading a public document? Saying that me reading this address was going to bring some freak to this house. I'm sorry, honey, but this case is well over 2 years old. It ain't going to be me reading a public document that's going to awaken the fire in some psychopath. Okay, so I don't have time for none of that stupidity. If you're that level of Karen, then you just don't even need to be on the internet. But we're going to go ahead and start going through this. But just like the rest of them, for the majority, a lot of this is going to be copy and pasted protocol, policy, case sightings, things like that. There's a lot more of the facts. Normally we get like 1 page. This one has close to 3. So we're going to have a little bit more information. It looks like definitely some more timeline stuff, but it also could just be at this point a big accumulation of all the other information from the other motions to suppress, because there's a lot of copy and paste fact as well. So let's just go ahead and get started and find out. Now, this is a motion to suppress all of the evidence gathered by law enforcement as a result of the entry into and search of Mr. Kohberger's parents' home at 119 Lambsden Drive in Albrightsville, Pennsylvania, including statements made after his arrest. Now, I saw some people taking that and like going with it. I am going to leave it like this. It gives almost a tiny bit more validity to what Bryan Entin and Bryan Entin only came out claiming that Bryan stated, was anyone else arrested, or asked, was anyone else arrested, something along those lines. Not why was I being arrested, but was anyone else arrested? And again, Bryan Entin and only Bryan Entin came out with that information and then stated he couldn't actually get verification on if it was fact or not. It started and literally stopped with him. But this could be something that he did say, because I have noticed that in the citations that they are putting in all of these documents, that they're not citing them the way that I was taught to cite them for you to actually be sticking to what you are stating and not putting anything in there that is unnecessary. You have to be extremely specific. So whenever they're quoting the Idaho rules, they're leaving in number 2. Instead of saying 1,3-8, they're leaving in number 2, which has something to do with a co-defendant. And we have been questioning the fact if there is somebody else that needs to be in the courtroom here or not. And I guess we might learn that during trial. But one thing that we have learned here is that trials really don't mean anything, do they? They really don't. Look at the Menendez brothers trial. The stuff about everything that they dealt with at the hands of their parents, especially their father, came out all over the place during the first trial, including family members taking the stand to verify what the boys were saying. Now, what happened come the second trial? Everything that mattered was not even allowed to be spoken about. Shh. Same thing in Delphi. Every bit of the discovery that was given to the defense, where they then came up with whatever they think happened based off of said facts, evidence, and discovery from the state, was then not allowed to even be presented to the jury. The jury was technically lied to the entire time. So when it comes to trial, sure, we can wish that we're going to get all the answers, but will we really? Now, the issues here seem to have a few additional things to it, so we're going to go ahead and read through these. This court should apply Idaho's exclusionary rule and law to this search. Mr. Kohberger has standing to challenge the search of his parents' home. Pennsylvania law enforcement violated Mr. Kohberger's Fourth Amendment rights by entering and searching his parents' home without a valid local warrant. The Idaho arrest warrant could not have given police in Pennsylvania the authority to enter the home. Federal and Pennsylvania law enforcement violated Mr. Kohberger's Idaho and Pennsylvania constitutional rights by not knocking and announcing their presence and presenting Mr. Kohberger with the opportunity to surrender, which I also found it kind of stupid. Even though it probably is protocol, I still found it stupidly asinine that whenever they went to go search Bryan Kohberger's apartment, they knocked a bunch of times and announced themselves before going in, knowing damn well there was an active warrant in Pennsylvania and they were all about to be raiding where he actually was over 2,000 miles away. They knew damn well nobody was in that apartment. So if they're going to knock, knock, hey, knock, knock, hey, knock, knock, hey, the cops, where they know nobody is actually at the house, but then they just enter and act like psychopaths where they know there's several people inside the home? Hella telling. The affidavit submitted in support of the application for the issued search warrant recklessly and intentionally omitted material information. The affidavit submitted in support of the application for the issued search warrant included information that must be excised. All information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic genealogy, and thus nothing in the warrant should remain. Information about the client's locations taken from his phone must also be excised due to being gathered from an invalid warrant. Statements after arrest are either fruit of the poisonous tree from the illegal arrest or should be suppressed as a Miranda violation. So now they're claiming that any of the things that he might have said are technically needing to be thrown out for two separate reasons. I'm sure we're going to find out exactly why here in just a second. Facts. Due to the haphazard way in which law enforcement has kept and disclosed records in this matter, the following are the facts relating to obtaining the search warrant for 119 Lambsden Drive. On December 28, 2022, Trooper Leary of Pennsylvania State Police became aware of the objective of arresting Mr. Kohberger via Moscow Police Corporal Payne. On December 29th of 2022 at 4:44 p.m. Eastern, a magistrate in Pennsylvania issued a warrant for 119 Lambsden Drive in Monroe County, the home of Mr. Kohberger's parents. On December 29th, 2022 at 2:22 p.m. Pacific, the magistrate in this matter signed an arrest warrant for Mr. Kohberger in Latah County. The affidavit for the warrant was signed by Moscow Police Sergeant Blaker. Not Payne, but Blaker. The basic facts Blaker used to support the search were. Now we need to remember that basically we are being told Blaker's PCA is the original. Payne then copied Blaker's, and there's also some information that maybe even Mowry copied Payne's, who copied Blaker's. So Blaker's is apparently the original. Next to the body of Maddie Mogen was a tan leather knife sheath. The Idaho State Lab later located a single source of male DNA on the button snap of the knife sheath. But we also need to remember that we were initially told that they didn't find anything, that the lab looked and looked and looked for DNA on that thing and couldn't find nada. Footage from the King Road neighborhood showed what the police suspected was the vehicle of the killer. But we also need to remember that whenever Fry came out claiming that he wanted to speak to whoever was in that vehicle, it was people and persons. It was more than one. This white sedan lacked a front license plate. So does another very, very important vehicle in this case. A vehicle specialist, notice the quotations. A vehicle specialist decided based on the footage that the vehicle was a 2011 to a 2016 Hyundai Elantra. A vehicle matching that description was spotted via surveillance in Pullman. It was later discovered that Mr. Kohberger drives a 2015 Hyundai Elantra and that he lived not far from the last place a white sedan was seen driving in Pullman over an hour later. The same specialist indicated the car seen in Pullman was a 2014 to 2016 Hyundai Elantra. But when did that change? That's what I want to know. Witness Dylan Mortensen had indicated the height of the person she saw at the time of the attack was between 5'10" and 6 foot, which is, again, that information that came out a few motions to suppress ago was interesting because the PCA itself does not put a cap at 6 foot. It just says taller, 5'10" or taller, which I showed you guys whenever we went over it before. And they had bushy eyebrows. Police determined Mr. Kohberger fit that description. Records from an August 21st, 2022 traffic stop showed Mr. Kohberger was the driver of a white 2015 Hyundai Elantra with Pennsylvania plates lacking a front plate. It also showed he had the phone number 509-592-8458. He noted investigators learned this was an AT&T number. Now, this is also a traffic stop that for some reason people are not able to get the footage of. We have the one from whenever he was pulled over in Pullman. This one was apparently pretty close to King Road, but they're refusing to let anyone get the info. A whole bunch of YouTubers in the beginning, whenever we found out about that August date, ended up filing FOIAs. Nada. They weren't given anything. Mr. Kohberger had changed his vehicle registration to Washington on November 18th of 2022 because he moved states and he was supposed to. That's what you do. Cell tower records did not show Mr. Kohberger was in Moscow at the time of the murders. In law enforcement's experience, however, people committing crimes typically turn off their phones. But this is Payne's experience. That's not his experience because the exact same statements of experience are in Blaker's PCA verbatim. Historical cell site location information, or CSLI, was obtained and given to Cellular Analysis Survey Team, CAST, with the FBI. The team determined that on November 13th of 22 at approximately 2:42 a.m., Mr. Kohberger's phone was utilizing cellular resources that provide coverage to his apartment in Pullman, Washington. They then support the idea that he left his apartment and went south. They then support the phone being off. They support at 4:48 a.m. that the phone is south of Moscow near Blaine. The phone utilizes resources that make their way back to Pullman, coinciding with a white Elantra seen on some surveillance there. A similar data showing occurs at approximately 9 a.m. with a trip to Moscow and returning around 9:30. A bunch of that was actually the same as a bunch of these other suppression documents. The same team determined Mr. Kohberger had been to Moscow on at least 12 occasions prior to the event and that he came into the area the morning following the murders. However, law enforcement, without explanation, indicated it did not believe that final trip ever occurred. Pennsylvania agents seized garbage at Mr. Kohberger's parents' residence and found DNA it determined was likely the father of the suspect DNA found on the sheath. At 2:43 p.m. on December 29th of 2022, a criminal complaint and probable cause order were filed in this matter. At 10 p.m. Eastern, Pennsylvania SWAT began preparations to arrest Mr. Kohberger. Despite weeks of constant FBI surveillance, Pennsylvania law enforcement did their own surveillance starting at 11:15 p.m. Eastern. And despite the fact that weeks of constant FBI surveillance showed Mr. Kohberger was unarmed, intended to go for runs around his parents' neighborhood, police decided that in the dead of night within his parents' home was the best way to make their arrest. On December 30th of 22 at 1:14 a.m., Pennsylvania SWAT raided Mr. Kohberger's parents' home. During the raid, law enforcement broke the front door of the home is where it should say, shattering the sliding glass door of the basement, held the entire family at gunpoint, and seized Mr. Kohberger. Mr. Kohberger made statements to his arresting officers. He was transported to a police station in Stroudsburg, Pennsylvania, and made statements during during transport. At the station, Mr. Kohberger was processed, during which police collected information about his person. Finally, during interrogation, before requesting an attorney, Mr. Kohberger made statements to interrogators from the Idaho State Police and the Moscow Police Department. We heard about these phone calls. We heard about this being over the phone. At 4 a.m. Eastern on December 30th, Pennsylvania State Police filed a criminal complaint against Mr. Kohberger. So now the 4 a.m. time frame is back in here again, because it's at 4:10 that they did then photograph him and take a cheek swab. So this is just making this even more wild to me, honestly, because this literally does make it sound as if they had the family completely at gunpoint for hours. Now, I don't know how long the ride is from the home to this police department. I'm sure I'll look it up at some point later on today and see just how long the drive is, because it's at 4:10 they're claiming that the photography and the cheek swab happened. And this is the 4 o'clock time that we heard about before that we weren't sure of, because there's a criminal complaint prior to the 1:14, and then there's this new criminal complaint at 4 o'clock. And I don't know what the difference is. I don't know why there's multiple. It doesn't honestly make sense to me. You're breaking into the home in the middle of the night because you suspect that he is the person who committed a quadruple homicide. The whole entire point is that you're supposed to match and make sure that things are correct. Did you have to go through all these hoops and red tape to steal the trash to do the DNA? Because where's that criminal complaint if you needed to have anything for that? Why is there two? If you were going in to arrest him, naturally the process would be to photograph his body for any wounds, any scars, anything that might look like it was from attacking someone, and then to do the cheek swab to match to the DNA that you have on file. That seems like that should have been protocol and covered under one complaint. So why is there two? Now, in this argument, they're going into the same argument that we've had when it comes to whose laws should be the ruling ruler, i.e., Idaho is the one arresting him. It doesn't matter that he lives in Washington. It doesn't matter that he was arrested in Pennsylvania. It doesn't matter that the feds are involved. Idaho's rules technically should be the ones that govern here. Mr. Kohberger has standing to challenge the search of his parents' home. Mr. Kohberger grew up in his parents' home, and at the time of the entry and search, he was staying there for winter break. This is going on to set a case from 1990, talking about how there was a house guest that was there with the permission of the host, i.e., Kohberger was visiting his parents for a holiday break. Thus, Mr. Kohberger was a son home for a weeks-long stay at his parents' home, has standing to challenge the entry and search in this case, regardless of his authority within the home. Pennsylvania law enforcement violated Mr. Kohberger's Fourth Amendment rights by entering and searching his parents' home without valid local warrant. But didn't they say that they did a criminal complaint? See, that's why I really need to go in and get that timeline together so intricately at this point, because you literally can't even be off by a minute in these things. It's going to matter. Pennsylvania courts require a warrant for a particular residence to go after a person police are aware has an arrest warrant. The need for a warrant for a fugitive from another state is codified in 42 Pennsylvania, and it's a Pennsylvania code 9128-9129. Without a governor's warrant, an officer can get a judicial warrant to permit entry into a home. Without either type of warrant, an officer lacks this authority. This understanding also comports with another case from 1980. The Idaho arrest warrant could not have given police in Pennsylvania the authority to enter the home. State warrants have no extraterritorial effect. The use of an out-of-state warrant is also ipso facto a warrantless entry. Thus, law enforcement in Pennsylvania could not rely on the existence of the Idaho arrest warrant to enter the home. And now we have a footnote. Note, there is an Idaho Court of Appeals decision, State versus Bryan from 2013, that seems to be counter to the holding in Bradley. The Bryan Court, however, never mentions or analyzes Bradley and does not appear to be aware of it. The holding in Bryan, I'm probably saying that word wrong, that name wrong, could not have overruled Bradley, and thus it remains governing law in this state. So they're just footnoting a citation of another case. As noted above, Idaho's law should apply to the entry of this case. However, Pennsylvania, like Idaho, has rejected the good faith exception. Similarly, it insists upon suppression where the knock and announce rule has not been complied with absent an exigent circumstance. The Pennsylvania Supreme Court has only found 4 exigent circumstances permitting police to ignore the knock and announce rule. 1. The occupants remain silent after repeated knocking and announcing. 2. The police are virtually certain that the occupants of the premises already know their purpose. 3. The police have reason to believe that an announcement prior to entry would imperil their safety. And then it goes down to this one right here and states, even though the exigencies are enumerated with the conjunctive and, courts have held that any one of the instances justifies non-compliance with the knock and announce rule, holding that the second exigency applied because a uniformed officer stood under a porch light and engaged the attention of at least several occupants with an announcement of his identity, authority, and purpose. Okay, and then it goes up to 4 and says the police have reason to believe that evidence is about to be destroyed. That actually makes me think if they were watching him through a window or something, or maybe had a spy camera in the house, because if they are telling us that he was in the middle of like separating trash or whatever, I don't know, the whole like evidence about to be destroyed thing just like popped into my mind, but they do know already that they've seen him apparently using other trash cans. So I don't know if maybe they just are going to end up using that as a reason why they went in and went crazy. I don't know. Again, they've said several times already that they knew that he would go for walks by himself or jogs, whatever, runs by himself, completely unarmed. They could have taken him after a run as he was coming back in the driveway, after he was a little bit, tired from running his entire route, and just taken him in then before he even got into the house, literally in the middle of the day. So why did it have to be all crazy like this in the middle of the night? Oh, man. In this case, there is and can be no showing of these exigencies. Mr. Kohberger had been surveilled by the FBI for weeks. At no point during this surveillance was he seen to have any weapons. There was no reason to take him inside the house, as surveillance undoubtedly was aware of his daily runs. We just said that. The evidence the police sought was simply not of the kind that giving him a chance to exit the residence would have imperiled. And then it states that there's really no circumstances like that they could give them that justifies breaking stuff in the home and destroying pieces of the Kohberger residence. There is no verification, justification, anything like that whatsoever. Pennsylvania cases show that the failure to announce in this case was egregious. And it says that in comparison, Mr. Kohberger has no criminal history, no reputation for violence, or even being a gun aficionado. It makes no sense that police are willing to announce themselves in Kitchener, other cases where there were more extenuating circumstances, and not to him. Taking the allegations in this case as true, there is still no explanation as to why a small army was required to capture Mr. Kohberger. Given the force the police decided to use here, there was no reason whatsoever to break down the front door, shatter the basement sliding door, and point guns at the inhabitants. And now it's going to go into the Fourth Amendment situation. This is the same exact copy and paste thing that they have used before. And then it just states that basically all of the information is proffered for a Franks hearing in support of this argument. It's filed in a separate motion and put in this the way that they have it here. The affidavit submitted in support of the application for the issued search warrant included information that must be excised, the same argument as the other ones. All information in the affidavit was gathered because of law enforcement's IgG coming from illegally obtained DNA. That is their main fight here, that they are fighting in a separate motion. It looks like everything else. And again, they're talking about separately in another warrant, Mr. Kohberger's AT&T account and the pin, trap, and trace device warrant should be excised. I just find it, again, y'all are probably so tired of hearing this, but they've literally complained about everything being copy and paste, and they're copying and pasting things into these warrants that are supposed to be for specific things, and they're putting in things that have something to do with something else. And now we have the Judge Hippler, telling them, you gave me a whole bunch of fluff here, and I need you to cut it down and be specific and get me to the point, because you've got like 2,000 pages and all these emails and all these things and nothing to tell me which one's relevant and which ones I need to be paying attention to. And I mean, I understand that whenever there's so much at stake here, to have to wade through all of the mud, they have enough resources to cut it down as much as possible. So now we're going down to statements after arrest are either fruit of the poisonous tree from the illegal arrest or should be suppressed as a Miranda violation. Any statements post-arrest of Mr. Kohberger are fruit of the poisonous tree from an unlawful arrest. In addition, statements made as soon as he was placed in zip ties and held at gunpoint by many police officers without a Miranda warning should be suppressed. And see, and it sounds like if that ride was like 40-ish minutes, they popped in there at like 1:14. They ended up filing the complaint and doing everything after 4 a.m. So let's just say from 1:14 until like what, 3:30? That's a long time to have a bunch of people rummaging through your home. You're sitting there, not in handcuffs, but in zip ties. I can't even it literally is like playing out like a movie in my head. Like seriously, it's ridiculous. Mr. Kohberger was zip-tied after a no-knock warrant was served. He was zip-tied at his hands and surrounded by police at gunpoint. Law enforcement did not Mirandize him immediately. Instead, they waited until after he was transported in a police car, handcuffed with at least 2 officers in the car. One was seated next to him in the back seat. A reasonable person in Mr. Kohberger's position would have understood himself to be in custody. 2 conversations took place before Mr. Kohberger was Mirandized at the police station. It is clear from the police station video that detectives asked him if he had ever been Mirandized before and said they needed to go through the formality of Mirandizing him. He said no. No video or audio recording of the entry into the home and initial arrest has been produced. So they're for real. They're for real. There's no footage. How many different agencies were on the ground? Are we serious? Video and audio begin with Mr. Kohberger in the police car. What is happening? I thought they were joking. Oh, they weren't joking. Okay. The conduct of law enforcement with Mr. Kohberger in the house is referred to as small talk when he is being recorded during transport. The conduct of law enforcement with Mr. Kohberger in the house is referred to as small talk when he is being recorded during transport. This cannot be verified because no audio or video is produced. The conduct of the officer in the police car during transport cannot be described as an interrogation. However, without a video or audio recording of in-custody discussions inside the house, the true nature of the statements made in the car are without context. All statements made at the police station were post-Miranda. Information in the media right after arrest and attributed to law enforcement report that Mr. Kohberger blank. I think this is Mr. Kohberger asked if anyone else was arrested. I think that's exactly what that says, and that is so crazy because I literally mentioned that earlier. Okay, such a statement is not in the police report or in an audio video recording that can be found in discovery. I'm telling you, I bet you that's what it is. If it is a statement that the state will seek to attribute to him at trial, it should be suppressed as a non-Mirandized statement. If the conversation with Mr. Kohberger inside the house was custodial in nature, that context may warrant suppression of the conversation in the police car during transport. I wonder if I'm right. I'm going to be totally fine if I'm not right, but I wonder if I'm right. Okay, and then this ends the same way about it being fruit of the poisonous tree, plus some statements may also be excluded under Miranda. Wow. Okay. Yeah. I am like seeing it like playing out in my head. That is just wild. And I do agree. Again, I've agreed pretty much every time that they've brought this up in these motions. If they watched him for so long and they could see that he never carried a weapon, that he went on runs by himself, they could have taken him at like any time in broad daylight and not done all this crazy stuff in the middle of the night, breaking literal pieces of somebody's private property, pieces of their home. That's just wild to me. But yeah, it is playing out like in a movie in my head. Dang. I really am going to sit down this weekend and try to get the timeline accurate by the way that I'm seeing the timeline, because that's wild to me that there was a complaint created in order for them to take the entry and then a whole nother one created hours later and then he was Mirandized. Like all those hours for what? What was happening? Apparently everything illegal if they're having to redo a criminal complaint later. I am so just very confused on this. Yeah, okay. Let me know what you guys think about all of this down in the comments. And for those of you that saw that I went fishing yesterday and didn't catch anything, well, guess what? Guess what? Today, Dad and my daughter decided to go because I had to work. I had to stay here. And they caught a monstrosity that my kids are now outside watching him fillet outside on the driveway as we speak. The picture for that is posted on my personal page. So there's a link for down in the description box and in the pinned comment. But do definitely leave me some comments about this one. I know by now most of you guys know all of this information. I have gone through these documents one by one, and the next one, finally at the end, is going through their motion to suppress the probable cause affidavit, the Idaho probable cause affidavit. Now, I don't know which one they're going to be actually wanting to have suppressed because, again, the public got Payne's, but the original one seems to be Blaker's, which we're going to end up having to go over and do a compare and contrast now in order to finalize the differences. And trust me when I tell you, if you don't know already, there's really hardly any at all. Okay, well, I'm off to cook some gumbo. Let me know what you guys think about all of this crazy information down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you were not subscribed already. And please don't forget to make sure that that notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.